Thomas Höppner, welcome to Digital Markets Research Hub. You've been very vocal and impactful actor in this relatively new discussions about shaping competition in digital markets and going after the largest players with different theories of harm. Some are older, more established, other are rather innovative, new, and they require further testing, and they attract a lot of attention. So I'm very grateful for the opportunity to discuss some of these issues, to present them to all of us. So maybe I can start with asking you that many people are really impressed by how the DMA is being proposed to be enforced in comparison to the competition law. So how would you characterize the evolution of this legislation, and how would you put it in this overall constellation of competition law enforcement vision, so to say?
I think the DMA is the direct response to shortcomings that have been observed with the ex post enforcement of traditional competition law. While the judgments speak in favor of the cases, at least so far, justifying that the investigations were started and also confirming the outcome, it was pretty clear that the hurdles for the authorities to get these cases through were so high that by the end, the problem may have kind of solved itself, because the infringing party had won commercially, and then the prohibition basically came too late. So I think it is obvious that the DMA has the justification for speeding up the process of prohibiting anti-competitive conduct, and I think it is already working in this respect, and I hope it will do well over the next years as well.
And if we look at your focus, you've been an academic, but also a practicing lawyer. So from which of many possible entrances you approach this new legislation, and which of specific core platform services appear to you being the most promising or the most decisive for the future of digital markets? So what's your vision about this, your specific vision about this legislation?
I think you have to look at which core platform services really allow the biggest control over access to end users or access to business users. The highest number of transactions, the highest distribution, where can you really control the matching of supply and demand? And these are automatically then the core platform services one needs to look at. So we need to consider operating systems, we need to consider search engines, browsers, and app stores. These are the primary matching points where end users end up selecting businesses and vice versa. So that is what the regulator needs to look at, and where a lot of manipulation has happened and can still happen, and where we need a bit more competitive neutrality.
You have commented a lot on the issues related to the US development as well, particularly on a recent case involving Google, Department of Justice versus Google. And many people note that the importance of this case is quite landmark, so it's quite distinct to other line of cases. Can you please explain to us what is at stake with this case, why it is so important, and what would be potential repercussions to other digital markets, I mean geographically?
Yeah, I think the response to the judgment was in several ways interesting. I mean, if you look at the case as such and the findings of Judge Mehta, it actually didn't bring much new to light. most of these elements had already been dealt with in the European Google Android investigation, which covered all those contracts as well, with a different focus, but still it was part of the analysis. So there was not much new in it. But I think why it brought so much attention was simply because it is a US case. And in the US, for so many years, they thought that their antitrust laws are kind of, I should say immune, but that what we do in Europe, that is all protectionism, and it tips the antitrust and can't be taken seriously, sort of thing. And all of a sudden, in US judges saying, well, what Google did wasn't really competition on the merits. And I think many woke up there and thought, oh, wait, maybe our presumption that what the Europeans are so worried about is protectionism, maybe that is wrong. Maybe there is more in it than we had thought. And the truth is, it is. And what I think adds to it is basically, like, from a legal perspective, the discussion about remedies. I mean, in Europe, we were pretty good at nailing the core issues, but we made the cases so kind of small that we really focused on the most obvious infringement to make sure they hold in court, that then the remedies only reflected these very kind of narrowly identified concerns. We only spoke about favoring of product searches, like comparison shopping services, why not all verticals, so things like that. So the remedies were equally far too narrow to really have a major impact. And in the US, in contrast, now that they have found a legal monopoly, the judge has brought a discretion to really impose remedies that make a difference, not just for some narrow conduct that was maybe the original focus, the contract with Apple, but really closing all similar paths that have left Google, with the power it has, and making sure we don't have the same situation 2 weeks later by them just changing a few contracts here and there and the same impact. So I think the remedy is really what makes the difference, that there's more to be feared on Google's end than in the narrowly framed European cases that pioneered in this field, but were too weak regarding the outcome.
Let me then extend this question, not speaking about specific circumstances of the case, or not even about specific implications, but I'm interested in learning your vision. You are Thomas Höppner as a practicing lawyer, a successful practicing lawyer, but also you are Thomas Höppner as a professor, as an academic. And thus, I'm interested in with this question, in your kind of understanding of the holistic enforcement mission, so to say. Is it feasible? Is it necessary? Is it doable to have a kind of overarching perspective about the end goal of this regime, or at least the long-term perspective, or the end goal is the sum of specific cases which we investigate or non-compliance investigations or in exposed modality? So is the whole vision necessary? Is it achievable? Is it definable? And if it is, how would you characterize, how would you describe it?
I think that's a complex question that needs a kind of a complex answer. I think we have to realize that we are dealing with very sophisticated technical systems, ecosystems of individual companies that, however, overlap with other ecosystems, where there are then alliances between those gatekeepers, contracts between these gatekeepers. They have their deals that make sure that their core businesses are kind of, shielded off the other party, but then they cooperate to make sure that no third parties come close to them. So there is a lot of stuff happening, and I hope that any future regulation in this is having a more holistic view on that, because It is pointless to just focus on individual cases where you think, oh, there may be an issue, but you forget about the interrelations with other cases, with other gatekeepers, and what this individual case means in the overall context. And we see this in privacy cases where they think, oh, well, this looks like a privacy issue. And then you think, yeah, but if you do that, it actually means that the monopoly power of whoever you are targeting is even increasing, because you are taking away options for challengers to do something about their own products, to improve their products and to challenge the incumbent. So we need to have a bit of a more holistic view, and therefore I would like to see authorities specializing more and looking more at the ecosystem of the companies, and also the relations between those, looking not just at the competition angle, also looking at the privacy angle, you know, having really a proper understanding of the economics and the technicalities underlying them, and why technical changes are often driven by economic incentives that may have an impact on a completely different market that hadn't been foreseen, but that the undertakings themselves know very well that if you change something in market A, the impact will be in market C the following, and that benefits them. And you need to consider these indirect effects, otherwise your decision may be counterproductive. And we've seen several of those decisions already, where the authorities then may even have thought they did something well, but turned out they didn't. And so therefore, I welcome, for instance, the approach in the UK that you've got a bit more kind of regulatory incentive, but also discretion for a very specialized authority to first analyze in detail how the markets work, what the key factors are, and to then define fine-tuned remedies that take all those interests into consideration and hopefully kind of reduce the main barriers to entry. While I'm less of a fan of a, you know, ex post enforcement of some kind of random cases where you lose oversight, and then maybe of different authorities that do not sufficiently cooperate with one another, so that they may even have, you know, counterproductive outcomes, because one does say A and the other one says B, and both contradict each other. So that's not ideal. So I think vision would be those that really deal with the core platform services. They need to be specialized. They need to do that every day. They need to do that very focused for a long period of time. They need to become total experts in this field. They need to know it from A to Z, and only then will they ever be able to kind of reduce the information asymmetry that we currently have, and that is so exploited by the gatekeepers. And we need to reduce that quickly, and only very specialized task force will be able to do that.
That's very convincing. I think it's in line with my understanding of things. I would obviously ask further questions about whether you need such strategic vision. Does it imply exclusive, or does it presuppose exclusivity? Does it presuppose discretion to turn a blind eye to some practices in order to be focused on this kind of long-term perspective? And does it presuppose the flexibility not to being continuously monitored and asked to provide justification for your conduct, which makes little sense if zoomed in and looked from the specific, and can be criticized? You become exposed to different types of criticism from people who endorse more proactive approach without seeing the broader vision. If this broader vision is visualized or definable, is it in your duty as an enforcer to make it clear, to present it to others, or by making it visible, you somehow inflate its value because it makes it also visible to those who you try to regulate? So if you are in the pilot cabin, in the management team of tailoring this very experimental, there is no textbook answer to this regime. If you are there in this sitting and designing the parameters, do you think it's possible to, do you have in mind the vision, or it's something which we all tailor while doing, it's kind of learning by doing, bicycle effect?
I think the vision is already enshrined in the DNA of the DMA. The vision is contestability and fairness. And these are the guiding principles. And as an authority, I would think, which cases have the strongest impact of getting me there? Contestability and fairness. So automatically, I end up focusing more on those core platform services that really make a difference and affect thousands of parties every day, and maybe leave other core platform services that I wouldn't say are more in the niche, but are not, totally determining our industry and our ecosystem. Leave that more maybe to private enforcement or kind of deprioritize it. But if you really want to get there quickly, you need to prioritize. And that means really looking at the major platforms that really shift supply and demand and match our businesses out there. And that is where I would put my attention to first. And then, if that means you don't have enough capacity for some other cases, maybe be open about it, but certainly be clear about it that this is something that can be picked up maybe by national authorities, maybe clarify we will not touch this, and then the jurisdiction should be open for others. Leave it to other authorities. There are so many other good authorities out there that could do the job, and you as a core enforcer focus on the central cases to really make a difference.
A quick question on this regard, and then we look to specific core platform services and business models. Do you believe in regulatory dialogue? Do you believe in amicable solution, or the stronger the stick, the better the result?
I think there's this notion that in a regulatory dialogue, you express your wishes and the other side says, oh yeah, if you like that, then I will certainly do that. But that's not the reality. It's not a dialogue between equal parties that are in a contractual situation with equal bargaining power. That's not the situation here. The situation is we've got a legislation that says these acts are prohibited. And you as an enforcement authority, it's your job to make sure that these laws are enforced. So there's no discretion about how do you, interpret the law in a way that I just ignored. There is no way. You have to enforce it. The regulatory dialogue only makes sense to decrease the information asymmetry or to be more clear what you as an authority expect. So I'm totally in favor of clear guidelines where the authority is saying our interpretation of this obligation is the following: A, B, C, D. This is our guidance. Please explain to us how you intend to implement it. We will look at it and tell you if that's enough or not. That is a form of dialogue I totally welcome. But I don't, agree with the idea that we kind of just sit around the table excluding affected third parties and try to find a balance where the gatekeeper is saying, well, what about this? Well, that would be a good compromise. It's not about finding a compromise with the gatekeeper, because any such compromise would, in case of doubt, impact third parties that have not been sitting on the table. So if you have a regulatory dialogue, it needs to be a trialogue, including those affected. And there we are talking about different businesses, end users need to be represented, business users need to be represented, any intermediaries. So it would be a rather complex dialogue. And I'm not sure whether that increases the speed or not. I think it would be more helpful also for legal clarity if the authorities really analyze the main provisions in detail and then express their understanding based on the law, on the recitals and all the previous precedents that exist. And then they have done their job, and it's up to the gatekeeper to take this on board and provide their solutions.
Thank you very much. Let us move to specific core platform services or the business models associated with them strictly. And one of the driving forces for digital markets appears to be, or the place where you can exchange your convert your digital muscles into your pecuniary muscles is online advertising. It's the machinery for generating income and scaling up your impact. Can you explain to us your vision? Where are we now with online advertising, primarily programmatic advertising, but maybe there are other types which are which require our attention? And is the situation pathological? If yes, is it curable? What would be the treatment if it requires a treatment?
Online advertising, as you said, is the lifeblood of digital markets, and the development it's going through is very problematic. Over the last 10 years or so, the amount of investment doubled in advertising, but much faster than actually the industries grew. What this suggests is that when it comes to digital markets, a lot of the payments is not traditional advertising as we understand it, to build a brand and build a reputation, make companies well known. It is pure payment to get access to end users. Because platforms say, I'm blocking your access to end users, and if you want to be seen, to be found, to be discoverable, you need to pay me. It's like a toolbox, really, where we say, well, you know, either pay me or you're invisible. But that is not traditional advertising. And sometimes, you know, there is this idea, oh, well, it's just advertising markets, and now they are more effective advertising there. It's not that they are more effective, these platforms, just it's the pure prisoner's dilemma. If I don't spend more on them, my products can't reach end users anymore. So advertisers are totally forced to shift their budgets there. But this has very detrimental impact on those industries where advertising was traditionally a key driver for quality and really important content. I'm talking about traditional media, editorial media, that I would argue has a far greater relevance to democratic opinion forming than those other platforms I just described. And we need them to be funded. We need them to be funded not by the state, not by subscriptions, because subscriptions mean end users will have to pay and they won't pay for it. So only the kind of the rich can afford several opinions to form their own opinions. That can't be the outcome, while those that can't afford anything will be bombarded with fake news from their favorite social network. This can't be the future. We already see the detrimental impact this is having. Platforms that don't give, you know, much attention to neutrality, to checking the facts, to editorial responsibility, those platforms are attracting more end users, attracting more advertising budgets, are growing. That's where the information consumption is taking place, to the detriment of traditional media that have a much higher standard when it comes to what kinds of facts do we express, what do we focus on our research upon. And if you look at the facts, it's really, really concerning. I mean, the advertising revenues for those traditional media are declining dramatically, and it's accelerating every year. By now, in 2024, I think it's 44% of all online, not all advertising spendings in every channel globally, 44% go to Google, Meta, and Amazon. I mean, this is it's insane. You know, the amount of newspapers, magazines, broadcasters, whatever you could hunt from this is just, you know, it's anyway. So it's a development that is concerning, because obviously there is a certain limit of how much an advertiser can spend, and any shift to these platforms in turn decreases the budget for traditional media. So they are totally marginalized on the advertising market, with all the consequences that follow. They have to let go of journalists. They have to let go of distribution channels. They need to let go of print versions. They need to narrow down their services. And we have already black spots in the States and in other countries where there are no newspapers left, no local newspapers, with the result that people don't get any relevant information anymore. And that in an information society that totally depends on reliable information. So it's very worrying for our society. And yes, the advertising markets are a key component for that, because if those that really push democratic values can't find the funding for it anymore, we can't be surprised that those that care less, will succeed and push those that care aside.
A few years ago, I had a conversation at the margin of an event with a representative, top-tier representative of UK media, one of UK media associations. And he was so excited when there were discussions in the UK that the largest online advertising machinery managers will be forced to allocate some amount of revenue, and he was talking about millions of pounds, using millions as if it's a lot, to special funds which will be funded, which will fund local journalism and investigatory journalism and all other traditional things which are being used as an illustration, as an impactful illustration to the catastrophic state of art in the industry. And for me, it was somehow a sign that rather than being more ambitious, rather than trying to design an alternative online machinery with other peers of traditional media outlets, or trying to bring more regulatory impactful recalibration of the status quo, it somehow, the industry appeared to be somehow subsumed to the level of, okay, we will get some crumbles from this luxurious party, and we will get some funds from those who generate billions and the trajectory of growth is impressive. Is it a systemic feature? Is it something which you observe? Is traditional media industry capable to put on the table something more risky, more ambitious counter agenda, or it's mainly about bringing in 2024 raising awareness and trying at least to slow down this asymmetric growth of one and decline of the others?
I think what you described is kind of a reaction of someone that I wouldn't say has given up on the notion of competition, but that has realized somehow, despite all our efforts, we are not moving forward. But what is important in this respect is the business model of ad-funded content has been developed by traditional media, and they know what they are doing, and it has worked very well, and it could also work in the online environment. But over the last 10 years, I unfortunately had to learn that all their endeavors to expand this concept to the online world have been boycotted and torpedoed by digital gatekeepers that reduce the targeting abilities of their advertising models, that made them look less effective to advertisers, that deprive them of traffic that they need for these models, that shield them off the eyes of end users, and conversely then also of advertisers. So it's not kind of by nature that these traditional media can't have a chance anymore on advertising markets. They are just opponents that are much more mightier through technology that hasn't been regulated for far too long, that makes their life so miserable and very difficult. And it's only a consequence of that you think, well, if you ruin our business model and don't let us expand it into the digital world, because in every end we come to you and you stop us, that they then say, well, if you mess it all up, then somehow you need to also be responsible and contribute a bit, because in parallel to messing up their business models, they earn on it. That's the whole motive for them, right? Take away the ad funds from traditional media and put them to our platforms. And therefore, I'm still a believer in competition. And I think if we manage to create a level playing field, then the traditional media can strive again. They are not keen on public subsidies. They are not keen on any what people call a gatekeeper tax and stuff, which wasn't the case anyway, right? Copyright law is not a tax. So So I'm a still believer that if you pave the way for proper competition between premium publishers and platforms, then this can sort itself out without any, subsidy from state or any sort of artificial funding. No real publisher or traditional media wants that. They want to be commercially independent. They want to earn their own money with their own effort and not kind of hinge on any state paying them on any tax or anything like it. That's not their vision. And it has worked very well, this business model, and I don't see a reason why it couldn't also in an online world if these artificial hurdles that are put in their path are finally taken away.
So, and the solutions which we witness, it's probably a ultra virus for competition mind even to start thinking about it. But the solutions which we observe as consumers of the media, like preventing these largest online platforms from indexing the content, it appeared to be that you only, however powerful as a media industry you are, as a specific player in the media industry are, you only marginalize your visibility, and people just there are some examples in some legal publishers prevent Google from indexing them, and they somehow barely visible at all, even for people who are subscribed to all this database. So I wonder if the answer would be more a possible solution requires more collective response. And would it be compatible with competition law? Should competition authorities somehow manifest their understanding that if different media players, while being competitors on specific media matters, decide to run some form of joint venture to put forward an alternative business model, or it's more about somehow curing patient who is in coma, rather than encouraging him or her to engage in more healthy lifestyle? Where are we currently? Is patient in coma, or they have some signs of ambitious counter agenda?
Yeah, I think that is a very important question. It relates to this really prisoner dilemma that gatekeepers create, where every single business user has no single chance to react to it. They could only collectively do something against the scheme that exploits them, but they may either be prohibited from doing a collective action because it may be seen as a boycott, or this kind of common sense we shouldn't do it is torpedoed by the gatekeeper incentivizing individuals within the group to kind of torpedo the collective effort. And we've seen that again and again, that like individuals are then picked out and kind of compensated. Look, you stop this whole collective countermeasure against my aggression, and in favor, I treat you a bit better than the rest of your group. And unfortunately, this works very well. And then regrettably, in the early days, we've also seen competition authorities prohibiting collective efforts like joint ventures of traditional media players that tried to bundle their content, bundle their offerings to a more stronger platform to gain network effects. And that was seen as, well, it is kind of an anti-competitive agreement and we should stop that. But the problem is that we want media plurality. We want many hundreds, thousands of broadcasters and press publishers. We want that. We don't want them all to build just one coalition that then we just have one or two. But this scenario of just reducing it to one or two is where we will end up if we leave it to the gatekeepers and their game of divide and conquer. Because this divide and conquer just means the larger publishers, the larger broadcasters, they will get larger and the smallest will all die away. And then ultimately we end up with much, much less media plurality. And that is when we leave it to gatekeepers. So the real or the proper reaction is to allow those many players to cooperate when it comes to defending their industry's interest. So if there is an attack from a gatekeeper, they must be allowed to come together and identify this as an aggressive attack on their industry and to agree countermeasures to make sure this is not, destroying the industry. And these countermeasures, if you look at the rule of reason approach in competition law, must be allowed, because these are not measures to reduce competition, but these are measures to prevent the foreclosure of themselves as players by a digital company. And I think that we will learn that these countermeasures need to be permitted, and we need more guidance on the permissibility of such cooperation. We've seen some of that in Japan, where they said, of course, you can come together to collectively agree on your approach and to ask for a collective license, for instance, stuff like that. But there needs to be more awareness from competition authorities that sometimes there's a pure need to come together to prevent being totally shoved aside as an industry.
And overall instrumentalization of privacy, we see it with Privacy Sandbox being one of the examples. Other largest online players equally use the vocabulary privacy, mediate their business users from end users. Essentially, we see it as ATT, we see it with some other. So it's kind of a new trend, essentially. Privacy is being, so the message, overarching message, which we hear more and more often, is that because we've been villains in the past, we understand that privacy matters, and we are in being one-stop shop. We are good guardians of privacy, and we will be protecting you. If you entrust your data, we have all these kind of procedures to protect the data, but at least you know that with all the third-party entrepreneurial minds, some are good, others are bad. You never been able to figure out. So it's quite an impactful regulatory narrative, so to say. We understand from competition perspective that it's being used in order to strengthen further your exclusivity in various markets. But it appears to be a trend. Do you see it as a trend, or it's something which is quite just sporadic, unsystemic, and thus easier to treat from a regulatory point of view?
I think there's a very clear trend, and if you look at the players involved and their cooperations amongst themselves, it's pretty clear where their interests lie. So if your business is based on search-based advertising and you are cooperating with someone that funds you because of search-based advertising, as in the case of Apple, naturally you will push search-based advertising and less so other advertising where you don't earn as much. So the incentive is crystal clear, and then you use or you look for excuses why you could make life harder for non-based search advertising, and then you stumble across the privacy element. You say, well, couldn't we draft some measure that makes life more difficult for others and sell it as a measure to increase privacy? Of course we can. So, and that's what happened with Apple ATT and with the Privacy Sandbox, where they just thought they could change the industry and sell it as a measure to increase privacy. And some actually fell for it. But the competition issue here is the relative data advantage. If I talk about fair level playing field in this area, I talk about a level playing field when it comes to access to data and the ability to use it. And it's simply not acceptable that on the one hand, you have got gatekeepers that amass tons of first-party data across various services, building a data pool that allows micro-targeting to a level that everyone should be scared, and rightly is. But then to use this fear of micro-targeting through the matters of this world as kind of a lobbying effort to say, well, now we need to disallow the combination of third-party data which never reached anything like it of the level of detail that first-party data combination has achieved. So there are two different worlds kind of collapsing, and if you look at what kind of third-party data is at stake, it's miles away of the micro-targeting that actually triggered the concerns in the first place. So And I'm really concerned about that. And then, already back when the GDPR was released, Nelly Cruz thought it's a measure against digital, gatekeepers, against big tech, but it turned out, they welcomed it because they knew it will increase this data regarding data access. And the broader this data, the more advertisers will come to their end because their targeting and measuring abilities are better in comparison to the rest of the world. And the shift that I've said is so problematic earlier on will just accelerate. So the privacy lawyers need to speak to the competition lawyers and vice versa. And we need a more holistic approach that really values the relevance of data, that appreciates what kind of depth of data is needed and where it is excessive. And we need to stop these excessive micro-targeting, primarily through first-party data, and enable the type of third-party data competition that only ever allows entry into the advertising markets for a broad range of publishers that otherwise would have no chance whatsoever to compete on the advertising market.
You have recently published quite a voluminous piece on self-preferencing, quite detailed, with many, you can see that it's well processed, many nuanced hints, even from not academic, but of direct practical relevance, are being manifested to the benefits of the readers. But I understand as a practicing lawyer, it's not the most intuitive business. There are few, Damian Gerardin, as Marcus Comnenos, who are equally nuanced in their analysis, but it's rather unusual still for the industry to release so much for gratis, so to say, to all of us. You obviously influence your position, amplify the amount of supporters, but it's, I imagine, vulnerable. So what motivates you to do this, A? And B, can you tell us a little bit more about this piece on self-preference?
Yeah, it's an interesting question. Also, some colleagues ask me frequently, why do you publish so much? You just give away information to others that compete with you, something along those lines. But I don't care about these elements. What I care about is really, if you are convinced of something and you think it's the right thing to do, you should do everything to get this across. And I really worry about these topics, and I worry about media plurality, I worry about competition. And when I think something is relevant to express and to shed light on it, then I publish on it. And it's also a reaction to what I've witnessed over the last 15 years in practice, but also with academic hat-on, that competition often doesn't have a lobby. The big monopolists, they can pay their economists and their lobbyists and all sorts of people that write articles that defend their practices. But the affected parties, the small parties, the many thousands of affected companies, they don't have these sort of resources, and they can't be bothered also to publish things that are generally in the interest of competition. So they have no voice. And it really bugged me over the years to read all these paid for non-disclosed articles that defend practices where you knew exactly they are so detrimental and they should be so prohibited. And some journalists then pick it up and take it for value, and because it's published by a professor, they think it's true. And it really, really annoyed me. So at some point I thought, no, I have to give some counter to this, and I have to at least express my view why this is wrong, and have to express what I think is right. And another point on it is I've realized that those battles that are really worth fighting, you cannot win on your own. You need to show others that what you're doing and what you're arguing for is right. And it is important that you do it. And you only get there by letting others know what you think. And publishing is a way to do that. And last point, many clients have kind of isolated concerns. They are only worried about what directly impacts them. But if everyone is just looking at the individual concerns, you quickly miss the overarching concerns, the overarching problem here that affects so many without them realizing that it's a kind of a problem that affects so many parties. So I see it as a bit of my task to then identify those overarching topics and make a piece on it to bring it forward, like the overall solution that would bring it to an end quicker than having to fight 20 battles one-on-one. And sometimes it reaches an audience, or it doesn't. But I'd also do it, because I think it helps the clients, even though they don't realize it maybe at the time. But somehow you need to do what you think is right. And I think publishing what you're convinced of is right. And I was always impressed with some colleagues that were, very sophisticated in expressing their views in this regard. And I try to kind of add a bit to it.
So maybe the second part of the question, I will connect it with another one. You also published in CPI Antitrust Chronicle a piece on AI, and thus jointly with self-preferencing issue, which you have also been quite detailed with articulating. My question would be, do you think that the emergence of AI is a momentum for others to somehow to move up in this global digital race, or on the contrary, it would only strengthen the stronger, make the stronger even stronger, and thus the elite club or the top tier of the largest players will only get more mature and the barriers will become even stronger?
That's a very good question that I also think about it a lot. Both papers on self-preferencing and on the implications of embedding AI in core platform services are related. Because if you look at the learnings from the impact of self-preferencing, what it has done to the markets and the various means how self-preferencing can take place, then you quickly realize in a world where we have even less transparency, because in addition to algorithms, you then have very opaque large language models and multiple language models being somehow linked, and then connections with the one and the other that are intransparent. In this totally non-transparent world, the scope for self-preferencing that can never be identified and never be detected, at least not for the next 10 years or so, is so high that you only have to add one-on-one together. Where are the commercial incentives to exploit this opportunity? And what can regulators do against it? And if you add the risk with the potentials, it's rather apparent that those that can use it to their advantage will do so. And they will feel rather certain that it takes years for them to be, put on the spot. And by then they have won the battle for, dominance in AI. And by then it doesn't matter, right? Similar to what Eric Schmidt said a few weeks ago, if your product isn't getting successful, it doesn't matter whether you copy paste it in the first place. So along those lines, I think we are currently seeing a lot of violations there, but regulators cannot identify them as quickly enough. And we will see them in 5 years or so, what has actually happened. But I think it's important, and I've articulated this from a very start already last February, my first piece on AI, that authorities have to be very observant, because currently measures are taking place that shift the dial, and we don't know whether we can shift it back again, whether this whole momentum can be taken back, whether we don't destroy industries now that can never be re-survived again or revived again, which are just dead and will never come back, and that we end up in a society that we call information society, but where actually finding relevant information is impossible. Everything is manipulated. You can't trust anything anymore, and those that would want to provide trustful information can't fund it anymore. So it's all linked to what we've talked about earlier on. Of course, AI also has chances. There's no doubt about it. But it really depends on what you define as chance. Is the chance that you can lay off a few journalists because some work can be done by AI? That's not a chance that is worth fighting for. is the chance really that you can push new companies to the fore that do traditional jobs better and are more efficient, provide a better user experience, and no hallucinations around it, then that's great, and we should really definitely move in that direction. And I'm using AI nearly every day, so I know the benefits of it. But what I'm really scared about, and currently it looks more likely that this is the way forward, is that those few that are in control of it, they just use those means to accelerate their shift to utter dominance.
Two extreme positions on the future or the role of regulators in shaping competition in digital markets, if not digital markets themselves. The position A, competition is click away, Yahoo, America Online, all MySpace, all these mastodons which somehow died, and newcomers from the dormitories emerged and started out of nowhere and started competition to brought it to another level, etc. And this is kind of, these cycles will emerge. We don't know yet, but who is now the next player? The radical, the extreme side of the spectrum A, and the opposite one is they emerged out in this Wild West wonderland with no rule, no understanding of things, no public awareness about privacy, and thus they've been able to generate their first billion in this kind of Wild West scenario. Now we introduce so many rules, GDPR, DSA, etc. Those potential newcomers are being constrained by so many regulatory requirements that they can generate their billion ruthlessly, so to say, and then become mature, more responsible, etc. So we somehow we constrain the oxygen for the bad guys, but also for those who want to scale up. These are two stylized metaphorical extremes, but I imagine there must be a lot of different shades, 50 shades of different in between. Where would you position your vision about obviously we need some alternative, and you can do it in federated way. It's another dream. Let's have many different small players. It's like internet idealism. Let's leave it aside. Imagine that you can only need the digital markets require big players. Can you explain to us how to do it?
Firstly, what you present is a correct version. Position A, I've witnessed and listened to for so many years. I'm fed up with it because it totally ignores the power of gatekeepers to suppress competition. So it's naive. Position 2, I understand that. Obviously there could be an incentive for those that are already in a strong position to get even more regulation, on board, so that they think, oh, well, we are already dominant. So if we make life more difficult for everyone across the board, then obviously our advantage will only accelerate because the small ones will find it disproportionately hard to comply than we do. I fully get that. But the answer to that is asymmetric regulation. Asymmetric regulation meaning you've got some requirements where you think this shouldn't be carried out by anyone, regardless of small or big. It's just not acceptable. It's something we don't want to see. And there's no excuse for not having that regulation in place. We need that even if it harms small players, but if we don't want fake news or we don't want people to copy paste and piracy, whatever, we need to prohibit it across the board. But then there are other barriers to entry, other harms that we have identified that cannot even be carried out by small players because they are not in a position to do any harm with those things. And then we need regulation that targets these barriers of entry that are put there by the big players and take them out. And these regulations then, by their nature, only apply to those already in power and take out the small one and give them no further burden. And if you put no further burden on those small players because they don't really put a harm in there, then there is no problem. And these two positions A and B go together very well. A, because if you take away the artificial barriers to entry into grow, then theory A is back with some plausibility that really startups with a better mousetrap can scale up, and there are no artificial hurdles to it, and they can replace the incumbents. But to get there, you need to take away the current artificial barriers to entry. And position B is also reflected because those asymmetric regulations that take away the artificial barriers to entry put there by gatekeepers do not harm startups because they are not the addressees of those obligations. So there's the symbiosis.
And this leads us perfectly to the DMA and DMCCA, which epitomize this vision of asymmetric regulation very well. So what is your assessment of the first? It's to have some people want the DMA to deliver from day one. How do you evaluate the first months? Are we doing a significant progress, or it could be done better? It's too early to say. And the sub question to this is the philosophy of anti-circumvention. It's definitely the idea is very logical, given the huge asymmetry of knowledge and all the capabilities. But do you think it would be it's this kind of cat and mouse game, that the cat is strong enough or the mouse is still fast enough to circumvent the anti-circumvention rules?
I think the anti-circumvention rule is absolutely key to the DMA. Let's start with a positive. I think the amount of changes we've seen this year, in a positive way, are probably unprecedented for the last years and are a direct impact of the DMA. And many changes are not discussed because gatekeepers have implemented them and they are fine, and people are not, concerned about them. They are just there and they are happy about it. And I have many clients that said, it's great that this change, finally we can do A, B, and C. But yes, again, the most important, mainly commercially important obligations, that's there still where the gatekeepers try to kind of hold back as far as possible and try to use the gray area as much as possible. And we see circumvention measures. But what I really like about the DMA is, one of the components is, they've got a tiered concept of remedies and sanctions. So you can play this cat and mouse game for a while, but if you overdo it and you get several non-compliance decisions against you, then it's not looking better, because then we are moving to structural remedies. And I think this is a very consequent approach. If you don't kind of behave and don't comply, then obviously behavioral obligations are not sufficient in your case, and we need to move on to structural remedies, and we need to split off elements so that the incentives, the conflicts of interest that you have, are taken out of the game. So I believe that this carrot and stick approach in the DMA is a good element. I hope that the current non-compliance investigations will lead to proper outcomes, that they are taken very seriously and not ending up with some compromises that lead nowhere, as we've seen in competition cases. The Commission, it is upon the Commission to use the full scope of their tools to make this a success story. Otherwise, the DMA and all the critics of the DMA will just win, and no one is served.
I wonder, how do you reflect, what are your views on the draft 102 exclusionary abuses guidelines, A, and B, how the line of high-profile 102 cases, which are due to be delivered in the following months by both courts, will affect the outcomes of the consultation?
I start with the second one. I think it's rather obvious that the amount of high-scale judgments that we will see in the next 2 months will have its impact on the final guidelines. Just look at the Google shopping decision. It was the second most frequently quoted decision of the General Court in the guidelines. So you can assume that the Grand Chambers final judgment will have an equal impact on the guidelines. But then there are also the AdSense and booking. So there are several decisions that will have an impact in Qualcomm and God knows. So we will see changes there. But coming back to the first question, see, I've been a practitioner that has filed several complaints, and most of them really were based on novel theories of harm. And that is a good, a very crucial component of Article 102, that it doesn't have a fixed list of prohibited conduct that you say, well, it doesn't fall under these 5 criteria, so it's fine. But there is a flexibility in that you need to identify the core evil. And if that is there, it doesn't really matter what label you want to give it. So within those years, the previous guidelines have played no practical role whatsoever. You know, I'm quite honest, in no cases have they ever played any role, because the ultimate instance that interprets Article 102 is the Court of Justice, and it's not the Commission. So in my view, the guidelines are far more important for the procedural elements, where the Commission kind of binds itself and lays out how it will procedurally approach these cases, than on the material components as to what is prohibited and what is not. Because there, the final say is with the court, and it would be a failure for the Commission to narrow down the scope of Article 102 by guidelines that don't go to the full reach. And it would really reduce the efficiency of the provision. So I welcome more those elements where they notice the failures of the more economic approach, that it can lead to a situation that the authorities are bombarded with pointless economic evidence, even though it's plain clear that you look at the facts and you think, well, you know, if you have any understanding of behavioral economics, that's the outcome that we will see in 5 years. We don't need to wait 5 years to get confirmation of that. So all this evidence-based, you know, you first need to show that someone is dead before you do something, you know, that needs to be fixed. Because we've learned, and we see it even more so in the United States, where the tying cases are dead because, you know, you have to wait until the tying already materialized, and everyone is dead, right? You know, what's the point of intervening then? So those conceptual mistakes, that they are addressed, that's what I welcome. And therefore, these ideas of presumptions, where it's rather clear where the thing is moving, is so important. And in dynamic markets, even more so, you need to react quickly. Otherwise, the whole intervention may be pointless. And if we don't make it easier for an authority and bring down the hurdles for them to fulfill, to bring a successful case, then it's dead law, and no one needs dead law. We need to empower the authorities, and that includes procedural flexibility in terms of you need to show what is important to show, to present the criteria that legally need to be fulfilled, but we can't make it too difficult on the evidence front and request them to compile tons of data and go through even more tons of data from the other side, only to state the obvious. So that's my view on the guidelines. I think there is a certain tendency to over-exaggerate its practical relevance. I see it more in the procedural elements than in the material components.
Thank you very much, Thomas. Last question regarding recommendations to students. You know the industry from the inside as a practicing lawyer, but you're also an academic, and as you communicate with students, you sense their how they change, what their potential, etc. Apart from the obvious elements of working hard and being a kind of diligent person and lawyer, knowing nuances, etc., do you witness some emerging element in the profession which is not self-evident yet, but by knowing which help potential newcomers to the market to offer to present their case in a more attractive and their personality in a more attractive fashion? It's something which they have to learn continuously, maybe for a couple of years, in order to advance a specific element of their practice and identity.
I have a rather clear view on that, also because being a partner, you need to hire people, and what do you focus upon when you do so? In my view, it's very important that while you strive for having an excellent overall degree, which is always helpful regardless what you do otherwise, you should try to specialize as early as possible. The days where lawyers do everything and anything are over. We need, I think, less general lawyers, also with AI and all this, and much more specialized lawyers, really experts in fields, and the world is getting more and more complex. Identify the field that you find interesting, but that also has some commercial relevance, so that you actually have some work to do there, and then just go for it. Become an expert on it, have your practical training there, your internships there, have a red line in your CV, pursue this path. Don't shy away from technically and economically complex areas. Seek those areas, because potentially these are the ones that will bring business to you in the future, and hiding with some seemingly simple field of law is not getting you anywhere. So go for the challenge, try to be as best as you can be, and really present your skills, work on them constantly. It's a marathon, it's not a sprint. So these traditional stigmas, they all apply, and they're all very true. And if you do that for a certain period of time, success will come.
Thank you very much indeed. Thomas Höppner, thank you very much for sharing your great ideas with all of us.
Thank you for the interview.